Whether detained or arrested and given a notice to appear at a later date, the first interview with the probation officer is very important.
And then the probation officer interviewed me, and they asked the same question that, the other officer asked me that night I got arrested. How are you doing? How, are you in school? Is there any problems at home? Stuff like that, to see like where you were at, I guess, what's your role in society?
At the juvenile hall, the child will meet with a probation officer, and that probation officer will call the parent. It's very important for the parent to provide positive information to the probation officer to show that it is safe for their child to come home and that they will take care of their child.
Ask teachers, coaches, people at church, and staff of programs that your child participates in for letters of support. Show these to your probation officer.
This probation officer will determine whether to conditionally release the kid or not. If they're not released, then the detention hearing will be held really very soon. So the judge will decide, whether to detain the kid or to release him or her.
If the child hasn't been detained, then they just come to court and they will meet with a probation officer. That first court appearance is really meeting with a probation officer. Generally, it is in the courthouse. It is very important for the parent to come with the child to talk to the probation officer and talk about whether their child is doing well or not. If the child is not doing well, it is extremely important that the parents speak to an attorney first.
After the first meeting with your probation officer, you will find out if charges can be filed and if your child can come home soon.
If it's minor cases that the probation officer has the discretion not to refer the case to the district attorneys.
If the probation officer decides that they want to keep the child in custody, there will be a petition that has to be filed, and that petition states what that child will be charged with, which is a criminal offense.
If charges are filed, there is a first jurisdictional hearing, the detention hearing.
During the court proceedings, the first court appearance is called the detention hearing. And at the detention hearing, it is very, very important for the parents to come to court.
Parents and who shows up for you becomes very important in the trust relationship of the court in terms of a release. And so any stable family that shows up in a courtroom and say, we are law-abiding people who've given good values and don't agree with what these accusations are going to be heard by the court, as opposed to no family being there.
Attend every court hearing and speak up in support of your child. Ask for an interpreter if you feel more comfortable speaking in your own language.
At that court appearance, which is the first court appearance, a detention hearing, the attorney will be speaking to the parents, and it's very important for the parents to speak very freely and provide as much information as they can to the attorney so that the attorney can advocate in the right way. It's important for the attorney to have any positive information so that the attorney can file motions for diversion or try to negotiate a charge that might be less than what your child is charged with.
In that way, I think it's up to the parent and the youth, but especially the parent, to become informed and understand what they can do.
No matter how angry or frustrated you are, do not complain about your child to the police, probation officer, or the judge.
It is extremely important for you to be very well prepared. And it is important for the child to be dressed appropriately. They need to dress like they're going to church or they're going to some important social function. So they need to make a good impression on the judges.
Pre-trial. There may be a possibility that the case can be settled without a trial. If the juvenile admits to the charges, then no trial is necessary. Ask your attorney for advice.
The probation officer will interview the minor and the guardians or the parents to gather information how much control the guardians or the parents have on the kid, whether they're capable of taking care of the kid. And so they just present the information to the court. For the pretrial report, that's it.
Between the first court appearance, the detention hearing, there will be a pretrial where the attorney for the child and the district attorney, who is the attorney for the state, will try to negotiate the case and try to work out some type of plea offer instead of going to trial. If the case settles at pretrial, there would be no trial. And what that generally means is that there would be an admission by the child that he or she had committed an offense and that it was true.
There's a finding in the pretrial hearing, then there will be a dispo hearing in about 2 weeks.
And usually the PD will often recommend that a student or that a young person make some kind of plea, either admit some guilt in exchange for a shorter sentence, a lighter sentence, really in the efforts to prevent their case from going to trial. If a young person is guilty and there's no way to hide that fact or get around that fact, sometimes making a lesser plea will be to their advantage. But oftentimes, a parent will take the plea or take that option to not go to trial and have the child admit the guilt because it's presented in a way that is really favorable to them. But the truth of the matter is that I don't think that's always the best decision.
If the case does not settle at pretrial, then a trial would occur.
The trial. When a judge hears evidence from the DA and the youth's lawyer about charges, the judge alone will decide if the charges are true.
At the trial, if the judge finds that your child committed a crime, then the case goes to disposition. Or if at any time from the first court appearance and through pretrial or possibly trial that your child admits to a charge, which is what we call a plea offer, the case will go to disposition. In adult courts, we call this sentencing.
Disposition hearing. When a judge decides the sentence and placement of the youth after reading the report written by the probation officer.
When they're doing the disposition report, which is the sentencing report, the probation officer will, at that point, will evaluate or assess. The kid just have to show how much effort or how much they want to make a change. And all the systems around him, if they can provide that kind of support for his positive behavioral change.
At the sentencing, there are a number of options that are available. The child could be placed back home in the community on regular wardship probation. We call it wardship, and that's probation. Probation generally runs for 1 year. The child could be placed on what we call 725A probation, and that is non-wardship probation, and this runs for 6 months. Your child could be taken out of the home and be sent to a group home, and group homes, the child could live in a group home for a year, sometimes even more. Child can be sent to a county camp, or if the charges were very serious, the child could be sent to the Department of Juvenile Justice, which is prison for kids.
Please look at your pamphlet for an explanation of different sentencing options. Again, parental support can impact the judge's decision in sentencing your child.